Hi, my name is Nadav Ravid. I'm the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country with respect to their commercial real estate leases. Each month, our firm publishes a DIRT report, which analyzes various cases and laws that impact real estate. Last month, we wrote about a case that came out of a bankruptcy court in Illinois that was one of the first cases to analyze the million-dollar question of whether or not rent is due during the COVID-19 pandemic. In that particular case, there was a uniquely written force majeure clause, and ultimately the court ruled in favor of the tenant and held that most of the rent during the period of time that there was a government order requiring the shutdown, that most of the rent was not due for a restaurant space. And so that was very good news for the tenants. This month, for our Ravid Law Group July 2020 DIRT report, we have written about a case that just came down out of New York, where the opposite is true, where the court has held, at least at a preliminary basis, that rent is due, or most of the rent is due during the COVID-19 pandemic. This case was a very interesting case. It is an interesting case that is being watched by everyone throughout the country. And the reason for that is that it's basically two big powerhouses going up against each other to answer these questions that all of us have about whether or not rent is due. This case presented The Gap, which is operating a store at Times Square, and also one of its other companies, the Old Navy store. Their flagship stores in Times Square against a powerful New York landlord, where the monthly rent is approximately $3 million. So $3 million per month, and the overall rent liabilities under the lease are in the hundreds of millions of dollars. And so what happened was sometime after the COVID-19 pandemic hit, Gap basically, starting in May, stopped paying their monthly rent. And so they didn't pay May rent, they didn't pay June rent. And when June came, the landlord sent a default notice to the Gap and said, that, hey, if you don't pay the rent for May and June, you're in default, and we are going to terminate your leases. Well, the Gap tried to stop the landlord from exercising that termination right. They sought what's referred to in New York as a Yellowstone injunction, basically asking the court to put a hold on the landlord's ability to terminate the lease while the parties litigated the merits of the case, whether or not rent is due. Gap actually took the position that the leases should terminate, except that from Gap's perspective, all rent should be excused based on the pandemic. While the landlord wanted to terminate the leases, recover possession, and sue the Gap and Old Navy for all of the future rent that is due under the leases, which again was in the hundreds of millions of dollars. So we have a lot of money in play here. Well, the court analyzed the issues. The Gap argued frustration of purpose, impossibility, impracticability, all the arguments that you would think that a tenant or retailer should be making in light of the situation, in light of the COVID-19 pandemic. But in this case, the judge, in essence, at this preliminary stage, ruled in favor of the landlord. It basically, the court held that all of the rent should continue to be due. And so going forward, the Gap must continue to pay this $3 million per month in rent while the parties litigate these issues. The Gap can't suspend their rent obligations during this lawsuit, which would have been a big victory for Gap had they been awarded that right. But the Gap not only has to continue to pay their $3 million worth of rent, but the judge also asked or required the Gap to put up effectively a bond for approximately $6 million to cover the rent that Gap did not pay for May and June. And the judge said, so long as you do those things, so long as you put up this effectively $6 million bond and continue to pay your $3 million worth of rent for both locations, your flagship stores in at the Times Square, then we will agree with you that the landlord will not be able to terminate your lease. But if you don't do those things, then we're going to allow the landlord to go forward with their lease termination and then to sue to recover the full rent under the lease. So the judge was not buying for now, that the gap should be excused from paying their rent. But the judge, again, it wasn't 100% victory for the landlord, because the judge did agree that because of the extraordinary circumstances, that's a quote from the judge agreed that that order, which required the gap to repay or to pay, to put up a bond for the rent from May and June, the judge gave the gap a 10% discount on those rents. So, suggesting that there should be some discount afforded to the retailers in light of COVID-19. Now, whether or not that will end up being upheld, whether or not that's any percentage, or whether or not the gap will have any sense of relief is still yet to be determined, but that seems to be where the judge is leaning based on the current facts and circumstances. We'll continue to monitor this case and update you as well as all other cases throughout the country. And that's it for now. Thank you.